busy. Got to stay warm.
There's so many lawyers in Alabama.
What do you do? What kind of law?
Well, down here, I guess I'm a commercial litigator. I do healthcare fraud. I work with the Department of Justice.
Oh, really? For the feds?
I work with feds. I do something called KETAM, which is Medicare, Medicaid fraud, Department of Defense spending fraud.
Whoa.
And then I do a lot of employment work.
Oh, okay.
So, yeah,
And where do you practice out of here?
I've got an office here and I've got an office in Nashville.
In Asheville or Nashville?
Nashville, Tennessee.
Nashville.
Yeah.
Yeah.
He's bifurcated.
Yeah.
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 And I have 3 children, so
I'll call this meeting of the Walton County Code Enforcement Board to order. Will we all please stand for the pledge to allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We've got a little bit of housekeeping here. Am I on now? Is that better? Nobody cares. Okay. In the November minutes, a word got added to the minutes, and we all need to approve the minutes as they now exist. And it is on page 204, down at the bottom, case 15655, John Wells, and the violation, section 20103J3, regarding, and it should say, it used to say regarding preservation areas. Now it says regarding residential preservation areas. And this correction was made by Dave Lovell, and we need to approve it included here.
motion approved.
Somebody second?
Second.
All those in favor? Aye. Okay. Did you get the motions? It was the John and Jack trip here.
John, Jack.
Okay, so that takes care of the November ones. I'll sign them and give them to you. And then the December minutes, has anybody looked at those? I wasn't here, Gordon wasn't here. Have you two looked at them, and do you have any additions or corrections to make?
I have no corrections. I don't.
No corrections.
And then
Let's approve them.
listen to the motion to approve.
I make a motion to approve the minutes for the December meeting.
I'll second
You'll
that.
second it. Okay, this time it was made by Jack and seconded by John. And all those in favor?
Aye.
Okay, so that's done. Okay, Mr. Davis and I met before this meeting, and I was informed of a case that,
Yeah, we need,
Yeah.
thank you, Mr. Chairman. We have a slight law change that we need to implement in terms of procedure as we move forward. According to, I believe it's the 3rd DCA, has ruled that we cannot set fines and liens at the initial hearing. As you know, what normally happens in these proceedings is we have a hearing to determine whether or not the person is or is not in compliance with the code. At that hearing, you are required to give them, if you find them not in compliance, you're required to give them so many days to get into compliance. In the past, we were able to rely on an affidavit from the code officer that they were or were not in compliance. So if they were not in compliance, then the original order would say an affidavit will be filed and then fines and costs are going to accrue at a certain rate per day. This court has ruled that doing that by affidavit and having a fines and cost and possible lien spring forth without a second hearing is violative of due process. So what we're going to do is we'll if you find someone in violation, we will tell them you're in violation, you have so many days to comply. If you do not comply, if there's an affidavit of noncompliance or you're told you're not in compliance, we're going to come back on this date. We'll have a date certain in the order, so we have no notice issues. You'll come back on this date, and you can argue that you are in compliance or not. And then if you find they're not in compliance after they were given that chance, then you can spring forth fines and costs. It's just one more step, but it does protect their due process rights. And there's a question.
The administrative?
We can impose the administrative fee. Yes. We, in the first hearing, we can still impose the administrative fee. Yes.
and then you could do a second one, I suspect, at the second hearing?
You know, the case doesn't say that, but I would assume you could, yes, sir.
Okay.
So you'll see a little change in the process, and we'll get around to amending the code to make sure the code reflects that.
Questions?
It's always changing.
Okay. I was informed that case number 1 and the third case are both not going to be heard. They were settled, I hope. No?
They weren't able to get notice to appear signed for, so due process.
Okay, due process.
Expect them to be here next month.
In any case, we'll start then with case number 2, number 14-264. Yes. And is anybody else going to testify in this case?
Mr. Johnson? Yeah. Were you wanting to testify as well? They're going to swear in. They're going to swear in.
If you're going to go ahead and speak on this, you might well stand and be sworn in.
Anybody who anticipates testifying today, would you please stand? Do you solemnly swear or affirm the testimony you're about to give before this code board will be the truth? Thank you.
Okay.
Mr. Johnson's case is case number 5, it's the last one on the agenda, however, he's the only one that showed up so far due to weather. Can we go ahead and hear his case first?
Certainly.
Then we'll swear in.
Yeah. So we're going to hear case number 15-625.
Those exhibits will be under tab number 5.
Okay.
Do you have another?
Go ahead, please. Would you give them all the exhibits to look at?
He's looking at it.
Okay. You have the right to object to some of these if you got good reason for it. Do you know what this is?
Pretty much attention.
Nimrod, sir.
Nimrod, yeah, I know what Nimrod
Where's
is.
that? What?
South end.
Where?
I think it's down there over Mount Bio, isn't it? Nimrod? Yeah.
Okay. Oh, I remember. Back up in my days.
Mm-hmm, you're right.
Wasn't this stuff all
It doesn't know where it is.
Hmm?
It doesn't know where it is.
It's, if you go down Mount
Steps,
Bio,
check.
you go all the way to the thing back in there. It's back in there close to back of all this stuff.
Hmm.
That's it.
Yeah, whenever you're ready.
Whenever he-
Is he done?
Where's that?
Oh, okay, I'm sorry, I thought it was
I
done.
think that's McFarland.
There's
That's
the
393 too.
Oh, no, this is over in Choctaw.
Huh?
It's over in Choctaw, isn't it?
Choctaw.
It's over there across the, that's where that circle is.
Tell us where this is.
It's right at the county line in Choctaw.
Here,
On
right
the north side of the bay.
Okay, that's
It's
right there.
north side of Bay, south side of 20. I mean,
Okay.
literally, you can see the.
I've seen it, but I've seen it down south end.
just before the 293 bridge. Okay.
If that's in the paper.
For sure it's in
I
Walton
think-
County.
Yes.
think that's what it is.
Might be the 293.
You got Choctaw bits on there? Yeah.
You ever been over here?
There's a seafood restaurant in there somewhere.
Yeah, there's Nicks and Sticks right over there. Right there next to that lake.
Yeah, I've been there.
They got a good fried mullet.
And they
Is
told
it
me,
taken with the West Point? Mm-hmm.
mistake go over there when they had the mullet.
It's not Santa Rosa though. It's in-
Okay, he's ready.
Oh, the mullet.
Okay, we're good. You have no objection to what she's about to present to us? Okay, then, look, here's how it works. She'll present her side of it, we'll question her, and then you get to talk about your side of it, okay? Please, go ahead.
Good evening, Stephanie Manning, Walton County Code Enforcement, regarding case number 15-625. Walton County versus Gary L. Johnson, 1028 Juniper Avenue, Niceville, Florida, 32578. On July 11, 2015, a complaint was received by Code Enforcement concerning building without permits. After a site investigation, it was determined that the parcel was in violation of ordinance 9728 of the Walton County Land Development Code, section 11.04.02.8, regarding building without permits. Finding the facts are as follows. The complaint was received by Code Enforcement on July 11, 2015, regarding building without permits on a vacant lot on Nimrod Circle. A site investigation revealed what appeared to be a two-story home being built on the property and also an above-ground pool that was not properly secured. That would exhibit 1A, B, and C.
Okay, we're going to accept these into evidence.
Property research revealed that Walton County parcel ID 30-1 south-21-4100-013-0050 belongs to Gary L. Johnson of 1028 Juniper Avenue, Niceville, Florida, 32578. Research also revealed that there had been no permits pulled for any type of construction on the property, and that'll be exhibit 2.
Okay, and we'll accept that.
On July 21st, 2015, a notice of violation was sent certified mail to the property owner, Gary L. Johnson of 1028 Juniper Avenue, Niceville, Florida, 32578, with a compliance date of August 25th, 2015. There'll be exhibits 3A and 3B. Exhibit 3B shows that that notice was received and signed for on July 29th of 2015.
Okay, we'll accept that into evidence.
And Mr. Johnson called me shortly after receiving the notice of violation to let me know that he did remove the pool, which was no longer a violation, and the structure was not an actual dwelling, it was just a shed. I advised him that with the balconies, blinds, and the visual appearance, as you can see in the photos, it appeared to be a dwelling, and that's why I referred to such in the notice of violation. At that time, I advised him that regardless of whether it was gonna be a dwelling or a shed, that it would have to have permits, and it was 2 stories. The 2 stories combined was over 400 square feet. He then stated that he did not feel it needed permits because initially his intentions was to build a 400 square foot shed and later added a 2nd story. I also advised him that if it was a shed and not a dwelling, that it would not be allowed on the property, as it then violates section 6.01.01.8 of the Walton County Land Development Code, which will be exhibit 4, that states you cannot have accessory structure on the property without a primary dwelling. And that, copy of that section is going to be exhibit 4.
Okay, and we accept that into evidence.
During that conversation with Mr. Johnson, he stated that he would not be able to come in and get a permit, he was going out of town, request an extension. I did give him an extension until September 25th, so that he could get back in town and at least submit a permit. On September 15th, I spoke with Mr. Johnson again on the phone, and he said he was having discrepancies with his surveys. Some were showing in the right-of-way, some were showing it in setbacks. He initially stated that it was an error in the survey, then later admitted that he did knowingly build it in the right of way, but that was due to the fact that he thought he was getting abandonment of the right of way. Unfortunately, that abandonment was denied, therefore leaving the structure not only without permits, but in the right of way. There were several phone calls that took place over the last couple months regarding his surveys. The county actually went out and surveyed the right of way. It's an undeveloped right of way, I guess you could say it's what has never been accessed. Once they didn't abandon it, that then put him in violation of that, but we did not cite him on that because one, we assumed he was gonna move it, and there was no use in restarting the case. He made several attempts to contact me to let me know that he was moving it and gonna get it permitted. October 19th, he called to let me know he was moving the shed, and he was still having problems with the boundaries. I told him to pick the best survey, at least get in, make sure it's well off the property lines, get it permitted if he's gonna go to the dwelling. If not, it would have to come off the property entirely as an accessory structure. He did come in, I believe it was late November, and attempted to submit plans. Unfortunately, he still didn't have a survey showing it out of the setbacks, and also the plans he had was just like a sheet of computer paper with 2 squares drawn on it. I explained to him that he would have to have professional plans and an accurate survey showing the structure was out of the setbacks. A few more weeks went by, he did continue to call and touch bases, dealing with surveys, architects, and a few different engineers. Unfortunately, it's going on for several months. We had to proceed with the case. On January 12th, I sent Mr. Johnson a notice to appear for tonight's code enforcement board hearing. And was sent to Gary L. Johnson at 1028 Juniper Avenue, Niceville, Florida, 32578, certified return receipt. The notice to appear was signed for on January 19th. That will be exhibits 5A and 5B.
And we'll accept those into evidence.
The site inspection was conducted again this morning by Officer Butler. That will be exhibit 6, which shows the structure is still on the property. There's been no permits pulled for as of today.
I ain't got to it yet, that's 5A.
We don't show us 6.
It's the very last picture at the end. Here.
Oh, okay, we'll stick
got
to
it.
5A. Okay, I see it, sorry.
You look at mine.
And that was this morning.
I think it's just that one piece of paper.
No, I got it.
Oh, you got it?
Yeah, if you peel them apart.
Oh, yeah, there it is, okay, they're stuck together. Thank you.
Okay, so what are you recommending?
We'll proceed with the finding of facts. This case comes before the public hearing before the Code Enforcement Board of Walton County, Florida on January 21st, 2016. After due notice to the respondent and the code board having heard testimony under oath, received evidence, heard argument, hereby issues finding of facts, conclusion of the law, and order as follows. The respondent, Gary L. Johnson, whose mailing address is 1028 Juniper Avenue, Niceville, Florida, 32578, is the owner of the property described as Lot 5, Block 13 of Nimrod Circle, Niceville, Florida. Walton County parcel ID 301 South 21411000130050. The following conditions exist on the subject property in violation of section 11.04.02.8 of the Walton County Land Development Code. The respondent received administrative notice on July 29, 2015. That notice advised the respondent that the condition of the property constituted a violation of the county code. The respondent was provided a reasonable time to correct the violation with a compliance date of August 25, 2015. Respondent failed to correct the violation on or before that compliance date. Staff is recommending an administrative fee of at least $450 on account of prosecuting this case for code enforcement action. Based on the foregoing finding of facts and conclusion of the law, and pursuant to the authority granted in Chapter 162, Florida statutes by motion made and duly seconded and passed by the Code Enforcement Board, staff is recommending that the respondent be required to correct the aforesaid violation on or before February 21st to allow 30 days to either come in and get the permits or remove the structure entirely from the property. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for inspection of subject property to verify that the property has been brought into compliance. In the event that county staff finds that the aforesaid property is not brought into compliance by February 21st of 2016, the respondent shall be ordered to pay a fine. The fine amount will be determined at a separate hearing held by the Code Enforcement Board after the compliance date with due notice made to the respondent for the new date. An administrative fee of $450 is assessed against the respondent and shall be paid on or before February 21st of 2016. A true and correct copy of these findings, facts, conclusions of law, and order shall be delivered to the respondent by certified mail with return receipt requested or by hand delivery.
And what was the date of the compliance? I'm sorry.
February 21st, 2016.
Which is also the date of the next hearing, is that correct?
It's a few days. He would go to the March hearing because it's
Okay.
the 18th.
Okay.
It's, yeah.
Thank you.
Okay, does anybody have any questions for Ms. Manning?
Yeah, let's go ahead and add that if there's not compliance, that we will have a hearing on March 28th, whatever date you said.
March 17th.
March 17th, 2016. Let's add that to the
Correct.
order as well. Yeah, we'll do that.
Okay. Mr. Johnson, it's your turn. Yeah, if you would.
March 17th, just to correct that, will be March 17th.
March 17th, thank you.
Okay,
March 17th, yeah.
I'm well aware of everything that's happened here as far as this goes, and I'm working out of town off and on, it's kind of complicated things too. Originally built it, as it stands right now, it's in required setbacks, okay? I was told all along that the sides were 7.5 feet each way, which I guess there's a stipulation in that area, I'm not sure what you call it, but it actually went to 5 feet, there's some documentation that had to be provided. So when I first came in and talked with her, and finally got my setbacks by the survey, I had to have another survey done, because I worked with Tucker out of Niceville, and they actually, a future son-in-law works for them as a surveyor on that county. They refused to actually mark the pins on the boundary survey where they should have been marked. Things weren't lining up according to the plat map. And what happened is a lot of time lapse, they're trying to get somebody to mark them boundaries because I couldn't get the setbacks. I didn't know where the west boundary actually was. And when I first did build it, I did cross over the line because I thought I was going to get the abandonment on Charles Street, which after 5 months of going through that, it never happened. So when it didn't happen, I went ahead and moved it back over to my side. Tried to take a winch and quite a bit of work to get it slid over. It's on skids. It's on 6x6 runners. I moved it over to my side, what I thought was my side. Well, I found out that the west boundary still wasn't there. Well, Tucker refused to mark the boundary, had another survey done by another independent come in, $700 to have it surveyed, so I could get the required setbacks to try to do the permit process. And that's what stalled everything up on the time frame on this, is trying to get the damn boundary established, because the boundaries out there is all messed up. The survey I got now, my neighbor to the east, 6 feet of his property is mine, if he has fence on now. And now there's a squabble now with that with the county surveyors, because the neighbor to the south, his house is in the roadway now, according to my survey. So now he comes and tells me little stuff that he's working with the county. And last I got with him, he said, I'm gonna have to move my building 15 feet back to the east, or to the west. And of course, let's what's going on with that. She said that's neither here nor there as far as my case goes. But I mean, that's what's going on out there after I had this other survey done. The boundaries are not correct. So finally, I got mine there, and that's when I brought it in and showed her the setbacks on my print from the surveyor. And that's what she told me that, you got it, it was like 6.9, and I had to be 7.5. Well, she read me the right act on that, and I come to find out later that I only had to have 5 feet, and that's for another individual that's familiar with the process in the area. I ain't gonna mention any names, but he told me that it should only be 5 feet. So the building right now as it stands is, other than the fact that I put a second floor in it, because I used 12-foot studs on sidewalls, and it's 360 square feet. But when I put the other floor up there to probably store stuff in, it actually, it did double the footage on it. But it was only set to be a shed. I moved down here from Indiana, and I'm a builder, I'm a contractor for it, carpenter, whatever. And I got massive amounts of tools and furniture that I'm living in a 30-foot RV still, because I can't find a place to buy, to move into. And that's why I made this thing like I did, because my lot's so narrow, I needed the space to keep the stuff dry. I got a storage in Valpese Field, 10 or 20 to the ceiling, and I got all this rubbish outside that's actually, I'm not a hoarder, but it's actually good stuff, materials, but I can't put it anywhere dry. And that's why I made the building the way I did. It's not, it was never intended to be a house. It's, you know, we played darts in there basically, and then, you know, that's all it was.
If you were to remove the second floor,
I asked about that, and that wasn't gonna be acceptable. I asked about that way back, I had no problem with doing that, and it said, no, it's too late, you've already been in violation, you can't do that, and.
She said
I
no.
put a trailer in and tried to take it down to make it conform
Wait,
to
she's-
360, and that's, no, you can't do that.
She said no.
Miss Manning, what?
We explained to Mr. Johnson that even if he removes the second story, and whether it's a house or shed, removing it, calling it a shed, even with one story, he still wouldn't be able to have an accessory structure without a primary dwelling.
Oh, okay, okay.
And see, I didn't see that on the website. When I looked at the website, it said the 400 and under no permit required. I didn't see anything about the other structure had to be on that property. And to me, it was like confusing because when I first mentioned it, I'm like, if a guy had a classic car and wanted to buy a lot, not next to him, maybe a couple lots over, and clear it and put a building on it, put his car in, you can't do it. And I didn't realize that you had to have a dwelling there before you could build a storage unit. I didn't realize
But you
that.
now do realize that?
Oh, yeah, yeah. Yeah, I realize it now. But I'm just trying, I've been fighting, there's other properties there, there's one that's a trailer on it, a lot, I'm trying to get, right now, the credit card didn't have to pull a loan on, even if I put $8,000 or $9,000 on something, I can't get anybody to finance me the lot to where I maybe move it over there without having to tear it down. I'm trying to get some kind of out without having to just mail it. And like I said, there's property adjoining me that I thought maybe that would be my out, since there's already a dwelling there, I could maybe slide it over there with a loader or whatever, and avoid having to demo it out. You know, because I hate, you know, there's a lot of equity, our equity there that, you know, it's, I mean, if it's tear it down, I gotta tear it down, but I'm trying not to do that, not to pursue double the avenue. I can't get an engineer to sign off on my bill. Called probably 30 of an area, had a young kid I thought was gonna be able to do some prints for me to submit for the permits, and then he won't even return calls.
Well, Mr. Johnson, let me ask this. Oh, I'm sorry.
Yeah, go ahead.
Do you dispute anything that Ms. Manning has said before this board tonight?
Do I know?
Do you dispute anything that the code enforcement
No,
officer
it's right.
said?
I mean, it's right, I mean, but I've tried to do as much as I can to comply, you know, to do this, but the property boundary thing was the biggest glitch.
Sure, and I appreciate that. I guess my question from my perspective is, you don't disagree with anything that she's told us, right?
No, not really, no.
Okay.
Everything's fine.
And you understand
I ain't
that,
gonna dispute it, no.
you also understand that you'll have time, if I understand, Ms. Manning, you'll have time to come into compliance after this hearing tonight?
Right. See, I've had time already, but it's,
Sure.
without the setbacks is the biggest thing, to get that squared away, with this boundary dispute with the neighbors and everything.
So are you asking this board to give you additional time beyond what you've already been given?
No.
Okay, because I don't know that we have the authority to do
No,
that.
I wouldn't ask that, because they've already been lenient enough with me. I mean, this man's already, you know, jeopardized her position, and doing what she done, and I'm grateful for that.
Okay.
I mean, it's a screwed up mess.
So what
I
could
mean,
this board,
I just need an easy solution. I mean, there's questions I have as far as, I don't know what it's gonna take to keep from having to tear it down. And to see, at one point, I thought there was a chance that I might be able to put a trailer in and pull permits on both, and everything would be okay, but I don't know if that's still an option at this point or not. I mean, because it's already been built before the primary dwelling was on the property, which I didn't know about.
sure. And I guess the fundamental point that I'm trying to make is it appears that everything Ms. Manning has told us to this point is true and correct, and that you agree with that, that you've been given additional time already, and that you'll be given additional time past tonight to be able to correct the violations. And if I understand Mr. Steiner to say that we could give you additional time even beyond that, which you haven't asked for, what resolution can we give you if you are in violation?
I'm not sure what you're saying. I mean, I'm okay with comfortable with the time they gave me already.
Okay.
And the only thing that really affect that is if I get a call from my GC that's in Indiana and they want me to hit the East Coast and start doing these advanced auto remodels,
Mhm.
then that puts me out of town again, see? And then usually those distances are so great, I don't come home on the weekends. I mean, you're talking, 16, 17-hour drives each way. It's not beneficial to come home, on the weekend.
Sure, and I can appreciate
And
that.
especially like go to Michigan or something, I just stay out until everything's completed,
Well, what is your plan? What do you think you can do to come into compliance?
Well, I mean, the only thing, I mean, I don't know, obviously, it's not gonna work if I take the top of the roof off of it and take the other story out I guess there's a height requirement too, the stipulations on the height of it, because I'm 22 feet.
Yeah, but I think you could work that out, but the problem is that you've got a shed and you don't have a primary
Right,
residence.
Well, I guess that's that's the other thing, I don't know if it's acceptable if I can find a mobile home to put on there or a modular or something. See, that ain't got my septic system in because I lost the money for that, fighting all this other crap. You know, I had initial money set back to do the septic system because that has to coincide with everything else, with the health department and the perk test and everything else. And now that's kind of gone, but I mean, I don't know if there's a chance of maybe getting a trailer to bring in there on the property and then have that surveyed, you know, with setbacks on where it's actually positioned, and go with that and try to roll it together. I don't know. I really don't know.
Mr. Carpenter, Mac's here somewhere, right? Isn't he here? Mac, can he put a trailer there? Would that count?
It would be a dwelling. I'm not sure if he has room for that or not. But it would be a dwelling, and it would qualify to have an accessory structure.
Okay. So, Mr. Johnson, do you understand what you need to do going forward?
If that's acceptable, that's not
Well, I don't-
feasible. I mean, right now, I've been turning all stones I can to try to figure out something, and it's just
Okay.
like my brain, and there's headaches, and, you know, my fiance on my butt about it. And
Well,
she's, you know, I've actually got the property owners that joined me wanting to buy the property now. And the one fellow said that he could get the building passed, no problem. So I'm like, well, what the hell am I doing? It's not, somebody else is gonna be able to do. I don't understand.
sure. And I don't want to overstep my bounds here, but it seems like everything Ms. Manning has told us is true, and you agree with it, that you are in violation. You've been told what you can do to correct.
On the footage and the height of it.
Sure, okay.
But I am in the setbacks. I mean, I did make sure that it got into the setbacks,
Okay.
and it had surveyed and everything with those points marked.
Sure, and I can appreciate that, but the point that I'm trying to make to you is you do agree that you're in violation. You do agree that you have to come into compliance. You've been told how you can come into compliance, and you've been given time to do that. Is there anything else that you want to tell us about your property that you think we ought to know that might otherwise?
Not really at this point. I mean, it's
Okay.
just, you know, it's,
You do understand that you do have to come into compliance.
what is it?
You do understand you have to come into compliance with the code.
Oh, yeah, I understand.
Okay, and they've given you time to do that and given you extra time to do that, and I think Mac's given you a pretty good idea on how to do it.
Right.
Okay, is there anything else you want us to do tonight?
No, that's I can think of now.
Okay.
How big is your lot?
Let's see, this time it's 56 by 150, I believe. But the rear of it's 43, I believe.
You got room to put a trailer in there? You think you got a room?
Front, yeah, I believe it can.
Stephanie?
Just to clarify while everybody's here, in the event that he comes to get a mobile home, the code does not allow you to get new permits while you're in violation.
Oh.
That mobile home permit would correct it, we would allow that permit to go forward as long as he can get proof that it's out of the setbacks. And so he can provide us proof that it's out of the setbacks. If he can correct the setback violation per se,
small.
then he would be able to get the mobile home permit. I just don't want there to be no surprise if he comes to get a mobile home permit next week and can't because this violation.
So-
Which, I don't understand the setback you're talking about.
Any side setbacks, any right of way, you just need to provide a survey, show that structure
Well,
is
that's what I brought you when I came, well, the actual survey with the setbacks,
At 6
from the surveyor, that was from the
6
surveyor.
feet 9 inches.
And that's right, he said that, and there's an individual that's a friend of mine that inquired if there's a 5-foot setback.
And that may be the case, we didn't pull the plat, we didn't go after setbacks, he's the one.
I don't know what it is, but there's some kind of stipulation going on with the lots in Bill Tasso there, that I felt like that position to work, I've only got to really be 5.
But the thing's on skids, right? It can move.
Right,
So you
So
can
you
get
can
out of the
move it.
setback no matter what.
I'm already within what's required.
Yeah, but if in fact you got to move another 0.6 of a foot, you could do that.
That's only if there's a tree close. Because that's where the winch goes, in the base of the tree. I mean, you know, we put 18,000 pounds of winch power to it to move it.
Okay,
You know, I mean, it don't look like it'd be that heavy, but it takes quite a bit to get it moved.
okay. But it could be moved. There's a tractor out there somewhere that's going to move it.
Well, there's a loader across the road there at the concrete plant. I bet if I had to, I could have it brought in.
Right, right. Okay, well, it seems like if you don't get called out of town,
I guess what I'm saying is, I know, I've already proven that it's within the setbacks on, I just don't know what that paperwork is for that 5-foot rule, but my surveyor pinned those corners and actually shot the elevation on the floor for
okay,
me.
well, that's something you got to convince code enforcement.
I mean, I don't know how else to do it, I've already brought the pin in from the surveyor. I mean, I don't know what's supposed to do.
Yeah,
No,
but
he's
the
not saying-
surveyor is not the county. You got to convince the county. And
What he's saying, and I
Yeah.
think what he's trying to say is this: that may very well be the rule. The county sees it differently than you do, and unless you can show the county that they are wrong and that you're right, the county's going to seek to enforce what they think the rules are.
Right, but I guess I'm not know what other paperwork would be needed. I mean, I brought in what the surveyor has gave me with the setbacks on there, with the measurements.
I think the expert's sitting behind you. She might be able to tell
I'm
you.
not an expert, that's Matt.
Well, that may be
I'd
Matt.
be happy to look at that with Mr. Johnson and check if he has a lot of record, an old lot that would allow 5-foot setback. My point of saying that was I just don't want him to come in and go get a permit and all he can't do that. If we can get him out of the setbacks and him provide a survey that's out of setbacks, we will allow the mobile home to be permitted while the current violation exists.
Okay.
I just didn't want to be no surprises later.
Okay.
Mr. Johnson, do you understand?
We're happy to help him.
Sort of,
find
but
that.
I guess I can get her to find out.
Yes.
Clarification on
Yeah.
how to get it out or whatever to make it comply. I mean, I'm not here trying to fight the system.
Okay.
I'm trying to comply to make you guys happy so I can get on, I'm still in an RV and I plan on getting the house a lot sooner now. And that 30-foot camper is really getting tight.
Sure.
And it's just, it's not what I thought it was gonna be 2 years down the road.
Sure.
Still on the camper.
Okay.
But you gotta have a dwelling on it before you can leave that building on it, right?
That's basically, and the footage is still over, so right?
Generally on this, he will come in and at least, I don't know how y'all need to make your motion between y'all and Mark. He will at least come in and apply for that mobile home permit and proceed with it and show us proof that that's under setback. We will look at it in a lot of record. If he wants to come down Monday morning, we'll check those setbacks if that is the case.
Okay.
That'll be fine, he can proceed with mobile home permit. We won't
Yeah,
hold the
it's
permit.
likely that it is. Mac and I were just discussing, based on the size of the lot, it may be what we call an old non-conforming lot. It may be qualified under Chapter 5. Chapter 5.
Yeah, there's some of them
That
in
would
Choctaw.
qualify.
I'm familiar with Choctaw Beach.
Yeah.
There's some
Okay, well,
of them.
look, he's not in compliance now. He came here, the contention is that he's not in compliance, and it would appear to me that he's not in compliance. We can give him until actually, he's gonna luck out, because the next time he's gonna appear before
Sure,
us
it'll be
isn't
March.
until March. If we give him till 30 days from today, and he isn't in compliance, but the hearing isn't until March, and the code officer comes back and says, the guy's making efforts to solve his problem,
Right.
then we can be done with it at that point. So unless there's more discussion, I'd sure like to hear a motion that he is not complying at this point, and he needs to come into compliance by 30 days.
I make the motion.
Okay.
I'll second that motion.
Okay, this time it got made by John and seconded by Jack. And any more discussion? Hi, Dave.
Just want to make sure that you understand the problems that you're faced with. That there's more than one, there's a right-of-way problem, setback problem, survey problem, and you gotta get some building permit.
I guess. I know my survey is right, on the setbacks, okay? The other thing I got confusion with is, I understand about the mobile home thing, and having required setbacks on that, as far as if I try to get one moved onto the lot. All right, so what I'm a little unclear on is on the building, what you're asking me to do. If you're asking me to drop because of the height, I have to take the roof down, eliminate the second floor, or pay a fine or whatever on that. I mean, I need to know what I need to do to the building structure itself.
Yeah.
As far as modifications,
That's not ours to tell you, that's Miss Manning's.
okay? Because I guess there's the height thing too.
We don't have anything to do with height, it's square footage. If it's gonna stay over
Okay, so-
400 square feet, it needs to you need to obtain a permit. You won't be able to obtain a permit for that until you have a primary dwelling with it. You can come in and apply for those at the same time,
So you're okay with the way it is right now, as long as I,
get a permit for it.
well, that coincides with actually trying to get a trailer moved on.
Yes,
that
he
as
should
well,
be able to
right?
apply for them
Okay,
at the same
and I
time.
think that's really super fair, I really do.
And
But I just needed clarification. No,
If you
no.
want to drop it down to one story under 400 square feet, you wouldn't have to have a permit, but you'd still have to have a mobile home permit. I mean, don't go.
Right, I still got
You.
a dwelling there, I believe it.
Yeah, so either way, come in and get a mobile home permit, if you plan on leaving it, if you decide to take it down to 400 square feet, it will not need a permit. If it's over 400 square feet, you will not.
Besides the mobile home thing.
Right, you
That's
can't
all I
run
would
them
need.
side by side though.
Right, but then you'd be okay with it as is, just get the permit for it.
Correct, based on that survey shows. with 60.
Okay, okay.
Do a call
Look,
motion.
we got a motion on the floor, and it's been seconded, and we need to vote on that motion. All those in favor? Aye. Any opposed? Okay. You know the process. You're gonna wind up in Miss Manning's office. You're gonna wind up in Miss Manning's office Monday morning.
That's fair.
Yeah.
I've never, this is
Very
the
fair.
third time I've ever been forward board, period, so it's all in.
It's a good education.
All right, I appreciate it.
All right,
So, Tom, I apologize for speaking over you.
it's fine. I'm not giving you a hard time.
Well, normally I'm better than that. I do these things first.
You're the lawyer.
I know. Not really,
You're a lawyer?
yeah. Not really helping the case.
Now we're in trouble.
I'm turning over to Jerry.
My apologies, I had understood we had a quorum, I had a conflict.
We did as long as all of us agreed we have a quorum. And we have so far, so you're cool.
But now that you're
Now,
here,
now somebody can disagree. Okay, so look, we've taken care of this case, the fifth case. Now we're gonna move back to the second case.
Yes, case one's not being heard, we'll now go to case two.
And is there anyone here other than you, the county, who's going to speak on this behalf?
I don't believe so, I have no contact. This is only request permission.
Okay.
Bear with me, this case is gonna be a little drawn out. This is one of JC's cases. We have to kind of start over with it, so it'll be a little bit longer than normal.
You talk pretty fast. You just keep going.
would it be best for us to pull Exhibit 11 out of our books so that we can follow the timeline?
If you, I put that in there just because I'm sure you're gonna ask, is it 11, if y'all wanna go ahead to that, this will be a timeline. And then we're under tab 2, and then there's 11 timeline.
Okay, it's tab number 2 then we're going to look at.
Just for clarification, it does date back to 2014, you'll hear dates 14, 15, and 16 of the case. There's
Okay.
no typos, or this is regarding code case 2014-264. It's John D. and Andrea Zardaski of 24 River Circle, Santa Rosa Beach, Florida, 32459. On May 21st, 2014, a complaint was received by code enforcement regarding a roof in a state of disrepair, junk and debris in an overgrown yard. After site investigation by Officer Alford, it was determined that the parcel was in violation of ordinance 9728 of the Walton County Land Development Code, section 11.04.02.a regarding building without permits, and section 5.07.0 regarding duty amendments. Finding of facts are as follows. The complaint was received by code enforcement on May 21st, 2014 regarding a roof in a state of disrepair, junk and debris in an overgrown yard. A site investigation conducted by Officer J.C. Alford on June 6, 2014 revealed that the roof was under construction and there was also junk and debris in the yard that was visible from the public right-of-way. That will be Exhibit 1. I do not have photos from the initial inspections from Officer Alford. There will be more when the new notice was sent out. Property research revealed, I guess I gotta let you accept that.
I'll accept it into evidence.
Property research reveals that parcel 28-2 south-33410-000-0010 belongs to John D. and Andrea Zardaski of 24 River Circle, Santa Rosa Beach, Florida, 32459. Research also revealed that there have been no permits pulled for the property. Read Exhibit 2.
We'll accept that.
On June 12th of 2014, a notice of violation was sent certified mail to the property owners, John D. and Andrea Zardaski of 24 River Circle, Santa Rosa Beach, Florida, 32459, with a compliance date of July 14th, 2014. However, those notices were returned unclaimed from the post office. So that will be Exhibits 3A and 3B.
Okay, and we'll accept those two.
August 6th, 2014, Officer J.C. Alford posted a notice of violation to the property for the compliance date of September 9th, 2014. Again, I do not have photos of that. We do have an affidavit of service that was signed by Officer Alford and notarized. That will be Exhibits 4A and 4B.
Okay, and we'll accept those in.
Shortly after posting the property, Officer Alford went out on medical leave. I was reassigned the case in July of 2015 after multiple phone calls and emails regarding the case. I re-inspected the property on July 29th of 2015. At that time, there was still junk and debris in the front yard and the roof was still partially completed. I researched the property and determined that no permits had ever been obtained even
And we'll accept those.
At that time amended and final notice of violation was sent to property owners who were notified of the case still existed and give them time to clean it back up. The amendment was due to an error being on the original notice of violation posted by Officer Alford. If you look on the actual notice of violation, in Exhibit 3, it shows 24 River Bend Circle, an error in the database. His mailings were sent to the correct address, the notice of violation for the affidavit has the correct address, but there was an error in the notice, so that's the reason for the amendment, which now included the correct address of 24 River Circle.
You're saying on Exhibit 3, they went to the wrong place?
It went to the right, or was sent to the right place, as you can see on his affidavit and also on the envelope, it does say 24 River Circle, but in the actual notice, the top paragraph, it said 24
Oh, gotcha, okay,
River Bend, for whatever reason, Navalon inserted River Bend as a default.
okay. We'll accept this then.
At that time, the amended notice of violation was sent with the correct address. That notice was sent on August 3rd of 2015 to John D. and Andrea Zarzasti of 24 River Circle, Santa Rosa Beach, Florida, 32459, with a compliance date of September 5th, 2015. That will be Exhibit 6A and 6B. We received one of the notices, correcting one of the letters back, and the other one has still never come back, and we never received a green card. Therefore, we have no due process on that notice.
Okay, we'll accept that.
On October 29th, 2015, at approximately 2:19 p.m., I attempted to hand serve a property owner with Officer Butler's resident. I spoke with a Miss Devin Black on the location, who stated that John Zarzasti was not home, but that he would be home later that day. I hand served her a copy of the notice. I explained to her the violations, the reason for the notice, how to correct them, and the compliance date. She said she would give that notice to him.
Who was that?
Devin Black, she stated that she was his son's girlfriend, I believe it was.
So related in
Yes.
at least some tangible manner. Okay.
And again, that was on October 29th. That notice of violation had a compliance date of November 29th of 2015. That'll be Exhibit 7A, 7B, and 7C. Also, in the photos for 7C, you'll notice that the junk and debris actually got a little bit bigger. It could be
Okay, we'll accept all those.
A site reinspection on December 8th, 2015, following the November 29th compliance date, revealed that the property was still in violation. The junk and debris was still visible from the public roadway, and no permits had been obtained or even applied for. Those photos will be Exhibit 8. So it's going to be 8A and 8B.
Okay, and we'll accept those into evidence.
Permission to post the notice to appear was granted at the December 17th, 2015 code enforcement board hearing. In the event we were not able to serve them with the notice, I attempted to hand serve the notice to appear for tonight's code enforcement board on January 6th and January 11th of 2016. No one appeared to be home, we were not successful, so we went ahead and posted that property on January 11th, that second attempt. With a notice to appear for tonight's hearing. That'll be Exhibits 9A, B, and C. There was a notice for both property owners attached to the front door. 9B will be the affidavits of service for those notices being posted. And 9C, there's a notice, the first picture is a notice being posted to the door inside of a screen and was laminated. The second picture of 9C shows those notices posted here at the courthouse front door in the box, as well as the third picture.
Okay, we'll accept all those into evidence.
As of today, January 21st, 2016, a site reinspection reveals the property is still in violation. The notices have been removed from the door. There have been no permits pulled for the property, no contact made with the property owner, and the junk and debris is still visible from the public right of way. That will be exhibit 10, which includes 3 photos of the site as of this morning. And again, exhibit 11 was already entered in, that's just a timeline of the case itself.
Have you ever made contact with anybody that lives there?
Is that your
We were
vehicle?
able to get contact either.
Is this your vehicle in today's picture?
I don't believe so. No, sir, we were told by a neighbor, the black car's his, so we were looking for that, he had the red truck. We never seen the red truck, but one time the white car was there. I don't believe he was home on any of our attempts.
Okay.
It didn't appear to me that that van, it looks fairly new, has been moved at all during this whole
No,
time.
sir, that'd be another thing that would fall under the 5.07.08 instead of packing 2 violations, so section B and C, we've done it as one. The junk and debris falls under that, and also the inoperable vehicle.
Okay. And we'll accept the 10 and 11 into evidence as well. And your recommendation.
Finding of facts and conclusions of law and order are as follows. The respondent, John D. and Andrea Zarzasti, whose mailing address is 24 River Circle, Santa Rosa Beach, Florida, 32459, is the owner of the property at 24 River Circle, Santa Rosa Beach, Florida, 32459, with a Walton County parcel ID of 28-2 South-20 -33410-000-0010. The following conditions exist on the subject property in violation of section 11.04.02.a and section 5.07.08 of the Walton County Land Development Code. The respondent received administrative notice on August 6th of 2014. The notice advised the respondent that the condition of the property constituted a violation of the county code. The respondent was provided a reasonable time to correct the violation. The final compliance date of November 29th of 2015. The respondent failed to correct the violation on or before the compliance date. The county has incurred administrative fees of at least $450 on account of prosecuting this code enforcement violation. Based upon the foregoing findings of facts, and pursuant to the authority granted in Chapter 162 Florida statutes, we're requesting that a motion be made and duly seconded and passed by the Code Enforcement Board by a majority vote and hereby ordered the respondent is to correct the aforesaid violation on or before February 21st of 2016 to allow for 30 days to correct the violation. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for an inspection of the subject property to verify compliance with the order. In the event that county staff finds the aforesaid property is not brought into compliance after February 21st of 2016, the respondent shall be ordered to pay a fine. A fine amount will be determined at a separate hearing taking place on March 17th of 2016. An administrative fee of $450 is assessed against the respondent and shall be paid on or before February 21st of 2016. And also a true and correct copy of these findings of facts and conclusions of law and order shall be delivered to the respondents by certified mail with return receipt requested or by hand delivery.
And just for the record, I just want to point out, there was 1 hand service, 2 postings, and 2 attempts by mail, so 5 attempts at notice. So I think we can feel very confident they know what happened.
He's made no effort to do anything.
No, so now you can see in the photos for today's reinspection, the notices are going from the door. There were lights on, it appears someone was there today.
And you've never spoken to anybody?
No, so we've never had a phone call, no written notice, no,
Other than the girlfriend.
other than the girlfriend, but we've never spoken with the property owner.
Right.
Okay. Any more questions? Okay, let's hear the other side. Oh, there's no other side to hear.
This one's easy.
I'll listen to a motion.
I make the motion that we adopt the findings of fact and the,
Did we find the violation still, or did I miss that part?
In the plan?
No, that's what you need to do. You need to,
I know there needs to
accept the
be
findings of fact and the
Okay.
notice and the, what'd you say?
Conclusions of law.
Conclusions of law. There we go. I should know.
and adopt the recommendations.
Yes.
I'll second.
Okay. Did you get it? Made by John, seconded by Dave. Okay.
Started by Jack.
Anybody, any more discussion? If not, all those in favor, aye?
Aye.
Any opposed? Motion carries. Okay, one more, and if you guys don't mind, we're gonna keep on going without a break. Okay. Can you keep talking? Do you need a drink of water or something? Okay, one more.
We'll be moving on to case 15-847, which will be tab 4.
We already heard 5, Dave. That was the one you wrote down. And 1 and 3 got taken off the agenda. Okay, so Terry Gandy, 15-847, right?
Correct.
And that's tab number 4, I bet you. Okay, go for it.
On September 29th, 2015, a complaint was received by code enforcement concerning an unsafe balconies in a building without permit. After a site investigation, it was determined that the parcel is in violation of ordinance 9728 of the Walton County Land Development Code, section 11.04.2.a regarding building without permit. The finding of facts are as follows. Complaint was received by code enforcement on September 29th, 2015 regarding unsafe balconies and building without permits at 37 Palmyra Way. A site investigation on October 6th revealed the rear balconies were under construction and the handrails had been removed. It also appears that the balconies are collapsing. Photos for the third floor, that'll be exhibit A and B. 1A and 1B.
Okay, we'll accept those into evidence.
Property research reveals that parcel 24-19-109-258-000-0040 belongs to Terry E. Gandy of 5001 Meadow Oaks Drive, Nolanville, Texas, 76559. That would be exhibit 2.
And we'll accept that.
On October 21st, 2015, a notice of violation was sent certified mail to the property owner, Terry E. Gandy of 5001 Meadow Oaks Drive, Nolanville, Texas, 76559, with a compliance date of November 25th, 2015. That will be exhibit 3A and 3B.
Okay, and we'll accept that into evidence.
That notice was signed for, as you can see on 3B, on October 27th, 2015. As of January 12th, 2016, I've had no contact with the property owner. No permits have been obtained or applied for. A notice to appear for tonight's code enforcement board hearing was sent certified mail on January 12th of 2016. The USPS site shows that was delivered on January 16th, 2016, though we never received a green card back. That will be exhibit 4A, 4B, and 4C.
Okay, we'll accept those.
As of today, January 21st, 2016, the property is still in violation due to no permits being obtained for the building activities on the property. I checked with both the planning department for a plan review and the building department. They both advised they've not had any permits issued or applied for that parcel. Those emails will be on exhibits 5A and 5B. Letitia Rashawn works for the planning department, checked for the plan reviews, and there's Linda Kelly is with the building department. She said they're doing the building department.
Okay, and we'll accept those. Recommendation.
In finding of facts, conclusions of law and order are as follows. The respondent, Terry E. Gandy, whose mailing address is 5001 Meadows Oaks Drive, Nolanville, Texas, 76559, is the owner of the property known as 37 Palmyra Way, Santa Rosa Beach, Florida. Walton County parcel ID 24-3 South-19-19-19-19-000-0040. The following conditions exist on subject property in violation of section 11.04.02.a of the Walton County Land Development Code. The respondent received administrative notice on October 27, 2015. The notice advised the respondent that the condition of the property constituted a violation of the county code. The respondent was provided a reasonable time to correct the violation with a compliance date of November 25th, 2015. The respondent failed to correct the violation on or before the compliance date. county has incurred administrative fees of at least $450 on account of prosecuting this case. Based upon the foregoing finding of facts and conclusion of law pursuant to the authority granted in Chapter 162 Florida statutes, by motion made and duly seconded and passed by the Code Enforcement Board by a majority vote, staff is recommending that the respondent is ordered to correct the aforesaid violation on or before February 21st, 2016, to allow for 30 days to apply for permits. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for an inspection of the property to verify the compliance with the order. In the event the county staff finds that the aforesaid property is not brought into compliance after February 21st, 2016, the respondent shall be ordered to pay a fine in the amount determined at a later date, separate hearing, March 17th of 2016, held by the Code Enforcement Board. An administrative fee of $450 is requested to be assessed against the respondent and shall be paid on or before February 21st of 2016. A true and correct copy of these finding of facts, conclusions of law, and order shall be delivered to the respondent by certified mail and return receipt requested or by hand delivery.
Can we add into the finding of facts that this property is not listed as his homestead in Walton County?
Why does that need to go in there?
We were getting a little more aggressive about collecting fines and costs. If it's not their homestead, it leaves open the possibility we could one day foreclose the land.
So we need to make it clear that it's not a homestead
We're
property if it
trying to
isn't.
shift
Yeah.
this.
Okay. Okay, any questions for Ms. Manning? I'll hear the motion. Dave?
I move we accept finding the fact and conclusion of the law as stated by Ms. Manning, and that's it.
I second.
We'll give Gordon credit for
Yeah,
this.
let me have one.
Yeah. Let him know he was here, yeah. Okay, all those in favor, aye?
Aye.
Any opposed? And the motion carries.
Can I ask her a question about that? Did they have the balconies up to start with, and they just took them down to change them, or what's the deal?
I believe so, based on the photos, you can see that the handrails have been taken down.
And then they had the little columns were all stacked up on the side of the.
I see where they're stacked up there, yeah. That's what was up there?
The front porch is also, you can see that they're literally busting, they're falling apart. I believe the front will be next, but we're not here for that.
But the construction of the actual porch is
It's been
adequate?
completed, yes, so we believe they were taken off.
Okay, but they
Replacing rocking.
weren't getting too heavy to make the porch sink or anything like
We
that?
don't know.
Y'all know?
I mean, that's.
I noticed, it looked like he was
It's
showing kind of
sagging,
a
yeah.
sway in
Yeah.
the top one, and I didn't know.
The third balcony actually had a large crack, and the photos aren't that great.
Yeah,
You can see the crack.
yeah,
So-
okay. Just curious.
Was it occupied? Had it been occupied? Could you tell?
There was
Okay.
no one home today, we knocked on the door.
You've got two notices, or two requests to permission to post that you want to bring to us?
We didn't vote.
Pardon?
I don't think we voted on the motion, did we?
No, we didn't vote.
Yeah, we did.
Yeah, we do.
Just now?
Yeah, all ayes.
We can re-vote if you want.
You're making me
I
doubt
didn't
my,
remember. I'm like you, I didn't remember.
my Alzheimer's, yeah.
Yeah,
That's right. You're
Gordon
right.
made his own motion.
That's
You wanna talk
right.
about
Yeah,
that?
Gordon, remember,
Yeah.
you got credit.
Yeah,
Okay.
yeah.
Okay, then we will listen to these two requests to post.
Good evening, Officer Butler, Walton County Code Enforcement. I have two, like to request permission to post for two cases. One is case 15-793. This is a junk and debris case. I've sent several notices and I've got nothing back. None of the receipts are coming back. Everything's being returned undeliverable. I'd like to request permission to post a notice of violation and also a notice to appear if that's not accepted as well.
Okay. Motion,
I make the motion.
second?
Also have another.
Well, wait.
We gotta
We're not-
approve it.
We got to vote. The motion was made by John and seconded by Jack. And all those in favor?
Aye.
No opposed? You got permission for that one?
All right, thank you. The next case is 15-951. This is another junk and debris case in Choctaw Beach. Since a notice of violation, it came back as refused. So for that one, I'd like to go ahead and request permission to post a notice of violation and a notice to appear if it's not corrected by the deadline.
Okay.
You
We all know what
go ahead.
refused means at the post office. I mean, I happen to know, if y'all would like me to share
Yeah,
that.
tell us.
It means that that person that received that thinks that that's offensive material. And,
We reached that level.
Might
Probably was.
Man, then he just didn't sign for it. He's supposed to sign for it, right?
you can just write refused on it, and it
Right.
gets returned at the expense of the sender.
Well, I make the motion.
Okay, all right, all those in favor? Aye. That motion carries. You have permission to post both of them.
Thank you.
Thank you. Any further business? Hearing none, I will entertain a motion to adjourn.
So moved.
Second.
Gentlemen, for all the hard work.
There we go.
Sorry again, sorry about that.
Good to see you, buddy.
How's everything?
Good, great.
Hope everybody gets your job out too long.
That's pretty good.
Huh? Both of us.
I got it figured out now.
I just don't know how you kept going with those numbers.
Sounds to me like.
I think I broke my darn finger today. I put